Great. Good morning. Thank you for joining us this morning. This is the Medical Legal Partnerships and Housing webinar presented by the Ohio Healthy Homes Network. It's one of 6 free webinars in the Fall Healthy Homes webinar series. Medical Legal Partnerships, or MLPs, as we'll probably refer to them today, are the collaborative approach between healthcare providers and attorneys that brings civil legal aid services into the healthcare setting to address social determinants of health among vulnerable populations. MLPs have a unique role in achieving affordable and safe housing for children and families, which will be explored in this webinar. Our discussion will include examples of housing cases that an MLP can help with and specific interventions that can be applied to help children and families attain safe and affordable housing. We have about an hour and 15 minutes for the presentation today, and we will hear from some experts and then have some time for questions and answers at the end. My name is Susan Jagers, and I will serve as the moderator today. I am the director of the Ohio Poverty Law Center, and we work with the legal aid programs across the state of Ohio. So before we get started, just to do some housekeeping, you can see some information on your screen, but because of the number of people participating today, we're going to have all participant lines muted and ask you to use the question feature in the GoToWebinar control panel to ask your questions. And if you can, if you have a specific presenter you want to ask a question to, if you could put that with your question, and I'll be moderating or monitoring the questions and asking those of our presenters. So if you are having any technical issues, use the chat box. The PowerPoint for this presentation is attached as a handout, and you can access that in the control panel as well and download that as a PDF, so you'll have those slides going forward. And then finally, this session is being recorded and it will be posted on the Ohio Healthy Homes Network website following the presentation. Next slide, Gina. So for those of you who are looking for continuing education credits, if you could use the chat box to put your name and your RS number in the chat box, both at the beginning of the webinar and at the end, that would be helpful. And a survey will pop up at the end of the webinar. And we encourage all participants to fill out the survey, but it is required for you to get a continuing education credit. So please make sure you fill out that survey at the end. Gina, then the next slide with the, actually before we go to, I want to recognize, thank you, I want to recognize the sponsors of the webinar series. You can see that there's a lot of support to make this webinar series possible. And the Ohio Healthy Homes Network extends its special thanks to the Coalition on Homelessness and Housing in Ohio for its help with the series, and a special shout out to Gina Wilt, who was in the introductory video and is a board member, Parker Dean and Josh Johnson. They were critical in putting together the webinar series in today's webinar. So now, Gina, if you can go to the panelists. We have a great panel for you today of experts, and I'm really honored that I get to be able to moderate the discussion around MLPs. I'm going to introduce all 3 of our speakers at once, and then we'll go through their presentations. And at any time you have questions, you can put them in the question box, and we will have time at the end to address questions. But if you want to put them in the question box during their presentation, that's fine too. I'll be keeping my eye on it. So first, we're going to have Carrie Stork. start off the webinar. She's the program manager for Lawyers for Kids at Nationwide Children's Hospital. She assists and helps to educate frontline clinicians with identifying at-risk individuals and families who could benefit from legal interventions in order to combat negative social determinants of health. Carrie also works with hospital staff on understanding why social determinants of health are an integral piece of providing holistic health care to the patients they serve. She's also a board member for the Ohio Healthy Homes Network. Next slide, Gina. We will hear from Jolene Wong. She's a family advocacy attorney with Lawyers for Kids at Nationwide Children's Hospital. She provides legal advice and counsel to patients and their families on a variety of legal matters, including family law, education, housing, and public benefits. Previously, she worked at a nonprofit in California advocating for public benefits and equal access to health care for people disabled by HIV and mental illness. She also spent 3 years as an attorney advisor for the Social Security Administration, where she advised administrative law judges and made recommendations on the adjudication of cases. And then our third panelist is Melissa Lenz. She is an attorney with the Legal Aid Society of Columbus and joined the staff in 2018 and is a member of the housing team, where she represents clients in evictions and housing subsidy terminations. She has also assisted clients whose landlords are not making necessary repairs with their rent escrow hearings on nuisance abatement cases. Melissa received her law degree from the Ohio State University Moritz College of Law in 2018. But while she was in law school, she clerked at Legal Aid Society of Columbus with the housing team, as well as Ohio and Disability Rights Ohio. So you can see we have a lot of expertise to share information with MLPs and housing with you today. And I will turn the webinar over to Carrie, our first presenter.
Thank you very much, Susan. Good morning, everyone. It's very nice to be speaking with you today. Again, my name is Carrie Stork, and I'm going to be talking about the MLP structure and learning a little bit more about the history and what we do. Okay. Sorry, just want to get where we need to be. Okay. Okay. Okay, so I thought we would start with an origin story. Back in the late 1960s, a doctor by the name of Jack Geiger hired an attorney to work at the nation's first federally funded rural healthcare center in Mississippi to assist with patients' food and housing concerns. Now, Dr. Geiger had recognized a need in his community, a need that the medical model may have been missing, but could be aided by the law. Now, Dr. Geiger found himself in new territory, but wouldn't be alone with this new thinking pattern. Fast forward to the 1980s, where the AIDS epidemic was taking root in the United States. At that time, doctors were starting to utilize attorneys in the healthcare setting to address the complex needs of these patients, particularly around end-of-life care and estate planning. Doctors serving these medically complex patients understood their needs, and they understood that they required a different specialty in addition to the medical model. Now, move a little bit further into 1993, and that is where the medical legal partnership idea really became into focus. Doctors at Boston Medical Center were noticing there was a disturbing pattern among their asthma patients. Regardless of patient adherence to their treatment plan, we're still coming back in with worsening symptoms, and it was confounding these doctors. After further investigation, it was found that these children and adolescents and adults were living in unsafe housing conditions, which was exacerbating their asthma symptoms. It was at that time Boston Medical Center had started to engage with Greater Boston Legal Services, and the medical legal partnership model was born. So, what exactly is a medical legal partnership? As Susan had already covered, medical legal partnerships integrate the unique expertise of lawyers into the healthcare setting to help clinicians, case managers, and social workers address structural problems that are at the root of so many health inequities. The medical legal partnership model has been implemented in over 400 clinic and community settings in 48 states across the United States. In 2019 alone, medical legal partnerships helped more than 75,000 patients resolve a legal issue that was impeding good health, trained more than 11,000 healthcare providers to better understand and screen patients for health-related social needs, and engaged in clinic and policy-level projects designed to improve health and health equity for entire communities. Now that we've talked about general MLP information, let's dive a little bit more into what the medical legal partnership targets. Here you will see some examples of social determinants of health. Now, social determinants of health are conditions in the environment in which people are born, live, learn, work, play, worship, and age that affect a wide range of health, functioning, and quality of life outcomes. That is quite a definition. A lot to unpack. But medical legal partnerships specifically target social determinants of health with the intent of improving these factors that greatly impact individual, familial, and community functioning. All of these listed social determinants of health have the ability to impact health. Particular social determinants of health that we know impact at-risk families that can be assisted with an MLP model include access to necessary medical equipment that could enhance quality of life, benefits denials that impede access to healthcare, unsafe housing conditions, living in environments that contain lead, mold, and other infestations, food instability. Food deserts are a common occurrence in at-risk areas. Food deserts are geographic areas where residents access to affordable, healthy food options, such as fresh fruits and vegetables, are very limited or non-existent due to the absence of a grocery store within a 1-mile radius. Individuals who live in food deserts are more likely to shop for food at convenience stores, which usually contain more high processed foods and less fresh fruits and vegetables. Access and equity regarding education, including not having access to necessary services such as occupational therapy, physical therapy, enhanced reading and math classes, or children and adolescents that face suspensions or expulsions, debt and other economic concerns which can impact the entire family unit. All of these social determinants of health that are listed here and the ones I just described can negatively impact mortality, healthcare costs, and health status of the individual and the community. Now that we've talked about MLPs and their roles in combating social determinants of health, how exactly does this show benefit to our community? Well, research has shown patients with access to legal care as a part of their health care are healthier individuals. Studies show that when legal expertise and services are used to address social needs, people with chronic illnesses are healthier and admitted to the hospital less frequently. People are more likely to adhere to treatment plans, including taking medications as prescribed and attending healthcare appointments. People involved in MLP services report less stress and can experience improvements in their mental health. And when legal expertise and services are used to address social needs, individuals, children, and families are more likely to be stably housed and their utilities are less likely to be shut off. Through teamwork and education, the healthcare team, when linked with attorneys, becomes more efficient. Medical legal partnerships can assist in identifying legal needs and providing resources and support. Shining a light on legal needs can help healthcare providers identify needs sooner, which leads to better outcomes. Medical legal partnerships can also serve as just the reminder that illuminates the social need and how that fits into the medical model. MLPs have also been found in previous studies to have the ability to reduce healthcare costs, benefiting at-risk populations. As previously mentioned, patients who are able to take their medications as prescribed, patients who are able to live in stable and safe, affordable housing, patients who are not being weighed down by extenuating life stressors. If we are able to assist with these domains, we can help individuals and families lead a healthier life. MLPs also assist in improving population and community health. Medical legal partnerships are constantly working towards providing best outcomes, which is to serve families living in inequitable conditions and provide legal assistance in order to increase equity in our community. In addition to helping patients attain better health outcomes, which can lead to lower healthcare costs, MLPs can also recover cash benefits for organizations, which provides additional cash flows for more community programs and for the healthcare providers that are involved in public health initiatives. Healthier individuals lead to healthier families and healthier communities. Now, there are many things an MLP is equipped to handle in the medical model or in a patient setting, but let's take a moment to focus on housing. There are numerous barriers that individuals and families can face when trying to attain safe and affordable housing. The MLP model can assist in overcoming these barriers by utilizing the legal team as a powerful intervention. Medical legal partnerships are in a unique position because of the multidisciplinary approach. The medical team can identify substandard housing via physical exams, blood work, and listening to the patient narrative. Through listening to the family story, a clinician can determine the barriers, such as unsafe housing, evictions, re-entry into the community after incarceration, homelessness, housing discrimination, or landlord and tenant issues. When those barriers are identified, the clinician can pull in the attorney to help families attain safer housing, thereby incorporating another layer of intervention into the medical model. There was a study published in 2017 where an MLP completed follow-up surveys and collected relevant information with veterans following their MLP intervention. Among a sample of veterans who were followed for 1 year post-intervention, the study reported significant improvements in housing, income, and mental health. Veterans who received assistance in more than one area of law showed greater improvements in housing and mental health than those who received fewer services. And those who reached their legal goals showed greater improvements in housing status and community integration than those who did not. Now, as previously mentioned, I am the program manager for Lawyers for Kids program at Nationwide Children's Hospital. Since I have provided some historical context on MLPs and how they were created, I wanted to share a little bit about Nationwide Children's history as well. The Lawyers for Kids Medical Legal Partnership program started at Nationwide Children's in 2013 at the Center for Family Safety and Healing. Now, that is a section of Nationwide Children's that specifically focuses on intervention for family violence survivors. That MLP was followed by another MLP that worked with outpatient children and families at Nationwide Children's through the ambulatory center, and that program began in 2016. NCH's MLP scope expanded even further with the creation of the Ohio Better Birth Outcomes Cohort, which is a collaboration between Nationwide Children's and Ohio Health, Ohio State Wexner Medical Center, Mount Carmel, St. Anne's, and other community organizations. Together, we serve at-risk children and families, pregnant women, and victims of family violence. Together, we have screened over 15,000 clients and closed over 3,000 cases. And together, we continue to reach our goals, which is educate clinicians on social determinants of health and how they impact patients and communities, educate patients and their families on legal interventions and why they are important in meeting healthy goals, and providing the interventions that are necessary to meet best outcomes. Now, we've covered a lot of MLP information so far and how social determinants of health impact our ability to thrive. But even after outlining the benefits of MLPs and the barriers that can be addressed, you may still be asking yourself, why legal services in the healthcare setting? Well, this slide details why legal services can be a vital component of healthcare, especially here in Ohio. 20% of Ohio children live in poverty. 80% of low-income households experience a social or economic problem that could have been remedied through legal means. And out of that 80% of households that could have been helped through legal representation, approximately 87% received inadequate or no professional legal assistance for their issues. Families are being bombarded with socioeconomic concerns that we can help with. Yet families are unable or do not know how to link with necessary services. And that is where we come in. Now, before I end today, I wanted to provide a few successful intervention stories to give you an idea of how we have been able to help through a medical legal partnership. The first two stories are specific to Nationwide Children's and our Lawyers for Kids program, and then the third comes from the National Center for Medical Legal Partnerships website. The first story regards a family who had been referred to us because they were living in a very cramped environment. The mom had a previous eviction on her record, and that was impeding her ability to find safe and affordable housing for her and her children. She was living with other family members, and that created a pretty cramped environment. She was referred to us to help with the past eviction. Lawyers for Kids representatives were able to contact her old landlord and the landlord's attorney, and they were able to come up with a way to, well, I should say, the landlord and the attorney agreed to vacate the eviction judgment. And that led to this mom and her children being able to attain safe and affordable housing. That was a huge moment for that family, and we were very happy that we were able to help them with it. Our second story talks specifically around housing condition. A family was referred to the Lawyers for Kids program because they were living in an unsafe environment. The house had a lot of leaks from the ceiling and from pipes. There were cracks in the walls. There were cracks around some of the outlets. There was actually a soft spot in the dining room floor, and it was so concerning to the family because they were afraid that if someone walked over it, that they would fall through the floor. There were a lot of concerns, and the family just didn't know where to go because the landlord was not agreeing to fix these. Lawyers for Kids stepped in, and they engaged with city code enforcement agency, who then inspected the home. They found a lot of different violations, including some emergency violations. Lawyers for Kids representatives engaged throughout the entire process. The house ended up getting fixed very quickly because of the emergency concerns. And we were very happy to say that the family was able to stay in their home, and it was much safer for them to stay in their home. And then finally, I want to highlight a story that comes from the National Center for Medical Legal Partnerships website. A child in Chicago was found to have some elevated lead levels, And it was found after an investigation of the family home that the lead levels were due to paint chipping from the walls. It was old paint and it was very toxic. The family was afraid to terminate their lease because they were going to lose their house. There was the potential of losing the housing voucher. And they had petitioned the landlord, and the landlord flat out was refusing to fix the problems that were causing the family to have some elevated lead levels. And then to make matters worse, when they were originally treating the first child to find that was found to have the elevated lead levels, it was found out that all of the child's siblings also had the same problem. His family was under a significant amount of stress. And at that point, they were referred to a local medical legal partnership. The medical legal partnership attorney petitioned Chicago Housing Authority and successfully obtained a reasonable accommodation under the Americans with Disabilities Act. This allowed the family to move immediately and retain their housing voucher. And then the MLP attorneys also assisted the family to make sure that they were moving into a safe and affordable house. So that was a good intervention, even though it had started at maybe a not so good place. So that is the end of my presentation. Thank you for listening and learning about medical legal partnerships. And if you were wondering where you could access some of the information I provided today, you can find a large bulk of it at the National Center for Medical Legal Partnerships website. They have an amazing website with, it's full of resources, full of peer-reviewed research, history, content, and linking with other MLPs across the country. So thank you very much.
Thank you, Carrie. It sounds like you are doing amazing work at Nationwide Children's Hospital. A couple of questions. How are you staffed, your Lawyers for Kids program staffed? About like how many staff do you have and what are their particular backgrounds? And then another question also is, how prevalent are MLPs in Ohio?
So I'll start with the second question. I believe there are approximately 21 medical legal partnerships in the state of Ohio. Melissa might be able to talk a little bit more about the MLP task force that partners with all of the medical legal partnerships across the state. But yeah, I believe there's about 21 of them. And there are some annual meetings where we all come together and talk about medical legal partnerships, some of the barriers we've had, some of our successes, things we found that work and things that we found that do not work. So that's a really great resource for us all. And in terms of the staff at Lawyers for Kids, we actually use a hybrid model at Nationwide Children. So we have our own staff attorneys that are able to assist children and families, and we also partner with the Legal Aid Society of Columbus. So we have two arms to our intervention, which means that we have the ability to help a lot of different families with their social determinants of health and making sure that they attain their best goals and outcomes.
Thank you, Carrie. I think we'll now go to Jolene. I think we'll be talking more about specific housing interventions. Jolene.
Thank you, Susan. Thank you, everyone, for having us here. My name is Jolene Wong, and I am a family advocacy attorney at Nationwide Children's Hospital. So I actually work for the hospital, so I'm on that hospital side branch that Carrie had just mentioned. So what I'm going to talk about now is some of the more specific types of cases that we typically see at the MLP. Let me get my slide ready. Okay, can everyone see? I can't see anything, so please say yes or no if you can see my screen.
Yes, we can see it.
Okay, thank you. Okay. So, you know, Carrie talked about social determinants of health and how outside factors can influence the health and safety of our patients. So specifically, how does unsafe or unstable housing harm kids? So we'll talk a little bit about that before going into some of the MLP cases that we see. Right now, there is an estimated 5.7 million US families living in substandard housing. So that's quite a lot across the country. And what is probably not a surprise to most people is that living in any type of unsafe or unsanitary home is related to greater emotional and behavioral problems amongst children and adolescents. And poor housing quality is related to poor school performance for older children. So, if you're living in a home that, has all these housing conditions that are just very unsafe, or if you're just not sure about how stable your home situation is, if you go, from homelessness in between homes, all of that really affects not only your emotional well-being, but it can affect your concentration, your ability to focus, and leading to things like poor school performance. One of the other issues with unstable housing is the availability of affordable housing units. Right now, there are about 25% of Ohio renter households that are severely cost burdened. That's a quarter of all renters in Ohio, which is pretty significant. And for every 100 families that are low-income renters, there's only 42 rental units affordable and available to them, so less than half. So that's quite a large discrepancy, which further leads to the negative aspects of those social determinants of health. And we're also seeing unstable housing affecting the African American community in a much greater sense. In Franklin County, the African American population makes up about 22%, yet 73% of families that are served in homeless shelters in Franklin County are African Americans. So again, seeing that racial disparity is very concerning, and unfortunately, I don't think it's limited to just Columbus or Franklin County. I think it's pretty much nationwide. So that's when, MLP interventions can really, come into play in kind of equaling that racial disparity. Additionally, every year there is about 19,000 evictions filed in Columbus alone. So that's quite a large amount. And we're expecting to see that number rise even more for this year, given the pandemic and COVID-19 and having it affect the economy the way it has. So that further contributes to unstable housing, which again contributes to negatively to kids and families' health. So some of the housing cases that we typically see at MLP include housing conditions, which Carrie talked a little bit about and we'll go into a little bit more details about, lease terminations, security deposits, evictions, housing discrimination, and reasonable accommodations or modifications. Let's talk a little bit about Ohio landlord-tenant law and where does it really apply and who does it apply to? Well, it applies to private rentals, so that's private apartments, private homes, so you have private landlords who are renting out space to tenants. It also applies to subsidized housing, such as public housing, Section 8, things of that nature. Subsidized housing is also protected further by federal law. The Ohio landlord-tenant law also applies to mobile home rentals, rooming houses, and land contracts. So we'll talk a little bit about landlord obligations. What is a landlord obligated to provide when they are renting out a home or property? The landlord obligations are all spelled out in Ohio Revised Code 5321.04, but we will talk about some of them today. Most of the common ones are keeping all common areas safe and sanitary, complying with local housing codes, making repairs to keep the home fit and habitable, supplying hot and running water, supplying garbage cans and pickup if there are 4 or more units, maintaining all appliances that are provided by the landlord, and landlord must provide 24 notice of entry into a rental unit unless it's an emergency situation. So these are some of the main landlord obligations that people should be aware of. Now, just the same that there are landlord obligations, tenants also have obligations that they have to maintain when they are renting a rental property. And that is spelled out in Ohio Revised Code 5321.05. But some of them include keeping the rental unit safe and sanitary, just the same as landlords, complying with local housing codes. Tenants have an obligation to not destroy the premises or any appliances that are included in the rental. They are not to disturb any neighbors or have any neighbor conflicts or things like that. They're not allowed to do drugs or really any type of criminal activity, obviously, in the rental unit. A tenant has to allow access to landlords after receiving proper notice from the landlord. And the last thing on here, which is very important to point out, is tenants are not only responsible for their own actions and making sure they're keeping up with these obligations, but they're also responsible for the actions of invited guests. So if a tenant, invites a friend over and the friend, accidentally or whatever ends up maybe breaking the oven or something like that, well, even though it was the friend who did it, the tenant is still responsible for making repairs to that stove because it was their guest who broke it. So that's one thing to keep in mind, that they're not only responsible for their own actions or any other tenants that are living in the home, but they are also responsible for the actions of invited guests. So one of the main types of cases we typically see at the MLP are housing conditions. Now, again, Carrie talked a little bit about that, about how housing conditions impact child health and how the MLP can provide legal interventions in ensuring that these conditions get repaired or the issue gets resolved. So some of the housing conditions that specifically impact health include insect and rodent infestations like roaches, mice, rats, bed bugs, things like mold or mildew, rotting wood, plumbing issues, leaks, water damage, lack of heat, drafty windows, broken doors, not having adequate air conditioning. Now, air conditioning is not something that that landlords are specifically required to provide, but if there is an air conditioning unit in the rental, then it has to be in proper working order. Same thing with other appliances. Broken appliances can lead to health and safety issues, same as broken locks and windows, and of course lead paint. So these are some of the housing conditions that we typically see. So if a client does have some of these housing conditions, what are they supposed to do? How are they supposed to get it repaired? And what do we do to intervene and assist? It really depends on what the tenant typically wants. If they want to remain in the home, they can put their request for repairs in writing, give the landlords a reasonable amount of time to make those repairs. And if not, then tenant can start escrowing her rent. And we'll talk a little bit more about that process. However, if the tenant does not want to stay in the rental and just wants to leave if these housing conditions are not repaired, then she would still send the landlord a letter that notifies them that if the repairs are not made, then she has the right to terminate her lease. Whichever option the tenant decides to go with, they should put their repairs, the request for repairs in writing. They should keep a copy of the letter and send it to the landlord with delivery confirmation. Now, what we typically do at the MLP in cases like this is that we do assist clients with drafting that letter to the landlord. We make sure that all the relevant law is in the letter. We make sure that every condition that's affecting the health and safety of the family is in there, and what specific repairs that are being requested. At times we will, represent the clients and communicating with the landlord. We will not only draft the letter on the client's behalf, but we will send the letter directly to the landlord, and we will call and follow up with the landlord directly to make sure that they are working on those repairs. However, there are times that, despite getting the request in writing, landlords don't do anything. They don't make the repairs, or they don't attempt to even make the repairs within a reasonable time. So that's when we have to go to these other options. So we talked a little bit about escrow and rent depositing. If a tenant does send the landlord written notice of the repairs and has given the landlord a reasonable time to repair, which we typically say is about 30 days, and the tenant is current in their rent, then he or she can file the escrow case at court. So what typically happens is she will go to court, let the court know that she wants to open up her case for escrow. She will have to provide, proof that she did send the written notice to the client or to the landlord. And at that point, the court will open up that account and she can start putting her rent in the escrow account in court instead of paying the landlord. And the court will hold that rent money until the landlord makes the repairs and the tenant is satisfied with the repairs. Tenants, it's important to know that tenants should never just take it upon themselves to not pay rent because the repairs are not being made, because that can trigger the landlord to file an eviction. So even though the landlord hasn't made the repairs, if a tenant is late in rent, even a few days, then the landlord will have grounds for an eviction. If the client decides, instead of doing the rent escrow, they decide to terminate the lease, we can also assist them with that. In Ohio, the only ground for breaking a lease without having to pay, the early termination fees is if there are conditions that materially affect a tenant's health and safety that the landlord has been notified of and has not repaired. So in the housing conditions cases, if the client decides that they just want to, break the lease, move to a different place, then this would be grounds to do that. And again, this would be something we would assist with. We would write the letter on behalf of the client, make sure the landlord is aware that this is a ground for breaking the lease and that they should not be charged any termination fees. If there are other reasons for breaking the lease, such as crime in the neighborhood, neighbor conflict, or domestic violence, unfortunately in Ohio, it's not a legitimate ground for breaking the lease. So in these situations, a tenant may still be responsible for early termination fees. However, even though legally a landlord is not obligated to allow a client to break the lease for these situations, we always encourage clients to work with their landlords, talk to their landlords, and we can even, advocate for the clients with the landlords, especially in cases of domestic violence. Like if you have a situation where your client is a victim of domestic violence and they are living with their, abusive partner, you can appeal to the landlord and let them know what the situation is and that this is basically for the client's health and safety to be away from her abuser. Landlords can be understanding in those situations and may agree to break the lease without having her pay those early termination fees. So other types of cases that we typically see at the MLP involve security deposits and the return of security deposits by the landlord. The law gives the landlord 30 days from the day that the tenant returned the keys to return the security deposit or to give a written accounting of how the deposit has been applied. So there are some circumstances where the landlord can either keep the whole security deposit or a part of the security deposit. And one of the things that they can keep it for is to pay for any unpaid rent or utilities or any other types of unpaid fees that are due under the lease. So if the tenant left the property, returned the keys, but they are still outstanding in their rent, then the landlord can keep the security deposit for that. The security deposit can also be applied to damage to the property that goes beyond normal wear and tear. So if the tenant caused damage that's beyond normal wear and tear, then the landlord can keep the security deposit or apply it to pay for those damages. And that can include things like, maybe a broken window if the tenant broke the window and it needed to be repaired, or making a significant hole in the wall that needed to be repaired. Those are some examples of things that are beyond normal wear and tear. Things like routine carpet cleaning or just general repainting and cleaning, things that landlords should do normally in between tenants, those constitute normal wear and tear, and the security deposit should not be kept for those types of fees. And what we typically do at the MLP is that, we do request the landlord to return the security deposit. We also go over any of the accounting that the landlord provides to make sure that any charges are considered beyond normal wear and tear. A lot of the times, landlords may just throw in some random cleaning fees, and the MLP attorneys can step in and say, well, wait, is this just a normal general cleaning? If it is, then it really shouldn't be applied to the security deposit. So that's how the MLP will step in cases involving security deposits. If after 30 days the landlord does not return the security deposit or provide any type of written accounting, then we would advise the clients to file a small claims lawsuit against the landlord for the return of that security deposit. And we can help the clients with that process. We can help them with the paperwork that they need to file. We can help them prepare for their case, how to present their evidence, what evidence to present, how to present their arguments in front of a small claims judge, things of that nature. So that is another way that we can assist with helping clients get their security deposits back. So that concludes my portion of the presentation. Melissa will go ahead and talk more about the other types of cases that we see at the MLP. But thank you so much for having us here to talk about, what MLPs can do for clients. And if there are any questions about the things that I just discussed, be happy to try to answer those now.
Thank you, Jolene. Just one question that came up. Has COVID-19 exacerbated any poor housing conditions that you've seen? So have you seen more or different issues come up during the pandemic?
Well, yes, I think one of the main issues right now that we're seeing due to COVID is the inability of clients to, pay rent or be up to date with rent, especially if they're losing work or they're waiting on their unemployment, whatever it is, and just being at risk of being evicted due to non-payment of rent. Melissa will talk a little bit more about evictions, but that is, a lot of things that we see. I mean, in terms of things like housing, housing conditions, maybe that hasn't changed, but the ability for clients to actually move, come up with money to move, put down a security deposit in a new place, that's been a real struggle. So a lot of the times the clients are stuck where they're at with these housing conditions. And, we have landlords also pushing back on the repairs because hardware stores aren't open, or they're waiting on getting the equipment to make the repair. So you're also seeing a big delay in getting some of these conditions fixed. So yes, unfortunately, COVID has caused a lot of additional issues with housing.
I wanted to add to that, Jolene, in terms of housing conditions, that another barrier is that, at least in Franklin County and in Columbus City code enforcement has not been doing interior inspections while they've been understandably trying to get their safety protocol in place. And so there hasn't been interior inspections. I'm pretty sure in most cases since March, they've only been doing emergency inspections. And so that has been a barrier for tenants to have that really helpful proof for the rent escrow case or for their, whatever case they may have about their conditions, to show that, yes, there are housing code violations here that the landlord hasn't remedied. And that's been ongoing during this pandemic.
Yes, that's absolutely right. Thanks for mentioning that. But yes, that is true. And I'll quickly just talk about a case that I had where we were able to get code enforcement because it was such an emergency situation, but it involved the police. Like a police officer actually came to the unit, inspected it, and was like, yes, this is definitely unlivable. And this officer contacted code enforcement and said, you have to come here and pretty much issue the citations.
Thank you, Jolene. We will now turn to Melissa. And as a reminder, we'll have time for questions after Melissa's presentation. So we'll go ahead and put additional questions in the question portion of the control panel, and we can get to those when Melissa's done. Thank you.
Hi, everyone. Bear with me while I get my screen ready. I think you can see my screen now. And can everyone see my presentation?
Yes.
Okay, thank you. So my name is Melissa Lenz. I'm a staff attorney with the Legal Aid Society of Columbus. I'm on the housing team. And as Carrie had mentioned, there was the hospital side of our MLP, and I'm on the legal aid side of that MLP. I'm on the MLP team at the Legal Aid Society of Columbus. And so I have the joy and pleasure of working with Carrie and Jolene on a regular basis, and I'm grateful to be here today. So I'm going to be talking about evictions, and also I'm going to briefly discuss the Fair Housing Act and how our legal interventions from our MLP clients can assist in these areas. Okay, let's get started. So just generally, I want to let you know that what an eviction is. Under Ohio law, it's also referred to as a forcible entry and detainer action. So those terms you'll see used interchangeably, but for the remainder of the presentation, I'm going to refer to them as evictions. Who is subject to an eviction? The vast majority of cases is a landlord bringing a lawsuit against a tenant, and the landlord is asking the court to give the possession of the property back to the landlord, and that the tenant currently maintains possession, and that's why they're coming before the court, is to get the property back. What kinds of cases come up for evictions? It's tenants who could be holding over their lease after their lease is up. The vast majority of evictions are for non-payment of rent. In Franklin County, it's over 90% of the cases are for non-payment of rent. If a tenant is breaching their tenant obligations, the ones that Jolene talked about in her presentation, and that breach materially affects health and safety, that can be the subject of an eviction. And also the breach of the written rental agreement. I think that Jolene and Carrie have already done a good job of talking about how housing and social determinant of health affects public health and an individual's health. And recently, the COVID-19 pandemic has only magnified the importance of housing and how evictions also play a role in public health. But in case you need more convincing, this slide is to talk about some recent things that have come to light amid the COVID-19 pandemic and how evictions affect those. So the tagline of this slide would be that if you can't stay home if you do not have a home. The CDC has found that keeping people in their housing helps facilitate self-isolation, first by people who become ill. If they're showing symptoms or if they've tested positive, they need somewhere to isolate. Or for those who are at risk of severe illness from COVID-19 due to an underlying medical condition. Furthermore, housing stability helps protect public health because homelessness increases the likelihood of individuals moving into congregate settings, such as homeless shelters, which then puts individuals at a higher risk of COVID-19. And this quote also comes from the CDC. And I also just wanted to highlight that even before the pandemic, the CDC has stated that 5 studies have shown an association between eviction and hypertension. So there was already known likelihoods of certain medical conditions for people who are facing eviction. But now, amid the pandemic, that hypertension is one of those underlying medical conditions that is known to have cited with more severe cases of COVID-19. Also, housing in congregate settings such as homeless shelters is, as this slide shows, an increased risk of getting COVID-19, and there have been outbreaks of COVID-19 at homeless shelters. That's been identified across the country. Because of these issues, recently the CDC has issued an order for an eviction moratorium. It became effective on September 4th, 2020, and this order determined that the evictions of tenants could be detrimental to public health control measures for slowing the spread of COVID-19. And this moratorium prevents landlords from filing evictions against tenants for non-payment of rent through December 31st, 2020. But this was not a broad moratorium against any eviction for non-payment of rent. Instead, it requires tenants, and the onus is on tenants to opt in to the moratorium. And for a tenant to be protected by this moratorium, they have to sign a declaration certifying that they meet the requirements of the moratorium. If a tenant doesn't know about this declaration, or if they've never signed the declaration, then they are not protected under the CDC's eviction moratorium. When they're signing this declaration, they're certifying that they meet the requirements, and I can briefly tell you what those requirements are. First, they have to meet a certain income threshold. It's under $99,000 per year, or there's a few other ways to determine if they are income eligible, and that's listed on the declaration. They also have to certify that they have made their best efforts to obtain government rental assistance. They also have to certify that they have been unable to pay their full rent due to loss of income or loss of compensable hours or layoffs or because of extremely high medical bills. They have to certify that they've made their, that if they were to be evicted, that they wouldn't have nowhere to go, and that they would have to move in with, like double up with another household in close quarters, or that they would have to go to a homeless shelter. And they have to certify that they will be making their best efforts to make timely partial payments to their landlord. And also, the tenants are still obligated to pay rent during this period. So now that we've highlighted a little bit more about evictions and the current public health issues, I can tell you a little more about just what eviction is under Ohio law. Before filing an eviction, a landlord must give the tenant notice. We commonly call this a 3-day notice. This notice is discussed in Ohio Revised Code 1923.04. The reason we call it a 3-day notice is that a landlord is required to give at a minimum 3 days notice before filing an eviction, but a landlord is permitted to give more than 3 days. They just have to give at least 3 days under Ohio law. This notice can be hand delivered, sent by certified mail, or left at the premises. If the tenant vacates within that notice period, then no eviction can be filed. And the notice must contain this language written in blue. I won't read it to you, but that language must also be conspicuous so that the tenant is able to see it. It can't kind of be like hidden somewhere on the paper. I'm going to briefly go over some common defenses. So notice problems. If the landlord did not give the notice to leave, that would be a defense. If that notice doesn't have the required language, or if it's not conspicuous, that's a defense. And then also the landlord has to wait 3 full days before filing the eviction. And they also, if they did give more time, they can't change their mind after that and just wait 3 days. They have to give however much time the notice gave the tenant to leave before filing the eviction. If this landlord serves the 3-day notice for non-payment rent and then accepts, well, actually even if it's for any kind of breach, if the landlord serves that 3-day notice and then accepts rent, that could be applied to future rent. That notice is waived and the case would be dismissed. But I wanted to explain what future rent means. So let's say, for example, that a tenant didn't pay October's rent and today their landlord gave them a notice to leave. If tomorrow the tenant pays the landlord September's rent, then the landlord can still proceed with the eviction. That would not be future rent. But if tomorrow the tenant gave them October and September's October and September's rent, then that would waive the notice. And because there's still a lot more I want to go over with this slide, I'm going to skip this slide and go and talk about the eviction time frame. So we're using July 2020 as an example of how these evictions can go, but this can be applied to any month. So let's say that rent is due on the 1st of the month and there's a grace period until the 5th. Tenant still is not able to pay their rent by the 5th, and the landlord hasn't received it. On July 6th, the landlord can tape a 3-day notice to leave the premises on the tenant's door with the grounds of non-payment of rent. I think there's a common myth that, you know, a landlord can't pursue an eviction after just 1 month's rent being late, but that's not the case. A landlord can proceed with an eviction as soon as rent is late. And so in this case, that would be July 6th. And they also have no obligation to accept late rent. So let's say the tenant didn't have the money through the 5th, but then on July 6th, they suddenly had all the money. A landlord does not have to accept it at that point. They can proceed with an eviction. That has changed a little bit amid the pandemic, but generally, and that's because landlords are understanding that there are more tenants who aren't able to pay rent on time, but just generally under Ohio law, a landlord does not have to accept rent late. So let's get back to the time frame. The landlord has to wait 3 full days. So in this case, it would be a Tuesday, Wednesday, and Thursday before filing an eviction complaint. So in this case, the earliest they could file the eviction is Friday, July 10th. On July 10th, the landlord files an eviction complaint, and in Franklin County, you get those set for 2 weeks out, and so that hearing will be set for Friday, July 24th. On that day, on the 24th, the tenant shows up and asks for a continuance because they want to try and find an attorney, and the case is continued for 1 week. The hearing, in the worst case scenario, takes place on July 31st, and the tenant is evicted for non-payment of rent. The landlord can purchase a red tag and then post it on the tenant's door even as early as that day. So 5 days later, the waiting period is just 5 days. And so if the red tag was able to be posted on the July 31st, 5 days later, the bailiff can supervise a set out of the tenant's belonging outside the apartment. So this time frame can be at its very fastest about a month from the notice to leave to the set out. One defense is if the tenant vacates before the hearing, the eviction will be dismissed as moot, and that may look better to future landlords. Because I know my 15 minutes are all getting close to being up, I'm going to skip this slide. This is about if a landlord tries to sue a tenant for money, that's called the second cause of an eviction. But in Franklin County, the vast majority of cases are the first cause only. So now to talk about the Fair Housing Act. This is the Federal Fair Housing Act. It prohibits landlords from discriminating against people in protected classes, and landlords can't discriminate in the process of attempting to rent the home, and then also it protects against people who are trying to buy homes. I'm going to be talking mostly about landlord-tenant relationships. Protected classes include race, color, religion, sex, national origin, disability, and familial status under the federal law. There are some additional protected classes in Columbus, Ohio, and then under Ohio law, but these are the main ones under the Fair Housing Act. I'm going to talk about disability discrimination under the Fair Housing Act for the rest of the presentation. So a person is disabled if they, under the Fair Housing Act, this is the Fair Housing Act's definition of a disability, is if a person has a physical or mental impairment that substantially limits one or more major life activities. And so major life activities include, caring for themselves, walking, learning, breathing, performing manual tasks, seeing or hearing. Another definition of a person with a disability is if they have a history of or are regarded as having a physical or mental impairment that substantially limits one or more major life activities. So this slide is full of information that I think is very important. So we're gonna start from the beginning, and we'll take it point by point. But first, so a reasonable accommodation or modification is part of the Fair Housing Act. It is considered discrimination under the Fair Housing Act against a person with a disability if a landlord denies a tenant's request for a reasonable accommodation or a reasonable modification. So first thing to remember is that a person with a disability must request this. They can't just hope the landlord knows they have a disability and that they're exempt from a certain landlord's rule. A person with a disability doesn't necessarily have to use like magic words. They don't have to say this is a reasonable accommodation request, but I would generally recommend using that phrase if the person with a disability is asking for these. So for a reasonable accommodation, that is something that's necessary for the disabled tenant to use and enjoy a dwelling unit. And a common example of this is if a tenant needs an emotional support animal because of their disability, that would account as an accommodation if the landlord has like a no pet policy for their units. A landlord pays for an accommodation if it's not an undue burden or a fundamental alteration. And so what that means for the emotional support animal is that a tenant is not required to pay any kind of pet fee. And one thing I want to highlight here is that for a successful reasonable accommodation, a tenant with a disability has to demonstrate that there is a linkage between that tenant's disability and this accommodation. So for the emotional support animal, that this tenant has a disability, an emotional support animal would help alleviate, symptoms of their disability or helps them with their disability in some way. And what we usually need is some kind of documentation from a doctor to prove that there's that linkage. And that's something that comes up and is very helpful with our medical legal partnership, that we can, we have access to their providers and can discuss ways that we may be able to help this patient get this accommodation that they need. And that also applies to a request for a reasonable modification. A reasonable modification is a change of the physical arrangements necessary for the tenant to use and enjoy a dwelling unit. And so that includes, like an example of this is handlebars in the shower. And so most of the time, a tenant is responsible for paying for a reasonable modification. I realize that I am almost out of time, so I just briefly wanted to discuss the difference between a service animal and an emotional support animal. And the thing I want to highlight here is that an emotional support animal does not have to be trained to do any kind of specific task, and that they are not something that they're not an animal that can go into restaurants or something. That's a different law. That's for service animals. Service animals are talked about in the Americans with Disabilities Act, but for the Fair Housing Act, emotional support animals are allowed by federal law to stay with people who are disabled in their apartments, even if they have no pet policies. An emotional support animal is not a pet because they're necessary for someone's health. And all they have to, there are kind of requirements for service animals that they do some kind of task for the person with a disability. But an emotional support animal, all that they have to do to meet their requirements under the Fair Housing Act is provide emotional comfort to more than one person, or even just one person. It doesn't have to be more than one. And for both service animals and emotional support animals, they do not have to be certified or registered. That is a common myth. There is no kind of registration or certification, and a landlord can't require that the emotional support animal be registered. And that's all that I have for you today. And if you have any questions, I'm available now. I think we have until 11:15, and this is my contact information also.
Thank you, Melissa, and everybody. We do have a couple of questions, so I'll jump right into them since our time is coming to an end. So do you have any examples of MLPs assisting willing landlords or community partners who want to provide new housing opportunities for vulnerable populations but are too concerned about barriers? So is there any outreach or education being done to landlord groups? I don't know. Maybe Carrie or Melissa address that?
I can say at Legal Aid that we focus a lot of our efforts on individual cases, and usually the vast majority of the cases we do are representing tenants. I am aware that we have done some outreach and education with landlords. I currently, this morning, cannot think of a specific example, but I I used to work at Ohio when I was a legal intern, and I think that they also do some outreach with landlords, but I can't speak to any specifics, unfortunately. Carrie?
I think you're muted, Carrie.
No, I did mute myself unmuted. Thank you, though. As for the Nationwide Children's Hospital side, we have not engaged with landlord groups at this time. It is something that we've talked about, but we do happen to focus a little bit more on the individual and the family. I do know that there are other groups at Nationwide Children's, though, that do focus really on bridging some of those gaps and helping landlords understand more of what they can do to provide healthier and safer housing.
Thank you. So this question may be for Jolene or Melissa. Are tenants allowed to request a lead paint inspection or risk assessment in their units, even without the landlord's permission? What other types of inspections can be requested, like for pets, energy audits, etc.?
So I am not as familiar with like lead work as some of my colleagues at Legal Aid. I am fairly certain that they can request an inspection for lead and they don't need the permission of their landlord, just like they can ask for city code to inspect without the permission of the landlord. The city code, for example, only needs the permission of the tenant living there. They'd always tell the landlord, like, give them a heads up if they're going to inspect. I do know that there's a process by which if a child tests with a certain level of lead in their blood, that that may automatically trigger some kind of inspection by the public health department. And it is, to my knowledge, that once that the child tests positive for a certain amount of lead in their blood, that they don't need the permission of the landlord. But I'm only about 75% certain of that. With other inspections, again, I don't believe there's any kind of requirement that the landlord has to give permission. It's that the tenant occupying the unit gives their permission. Jolene, have you found that to be the case as well?
Yeah, I agree with Melissa. I think it's the tenant who is living in the unit. And I think the lead issue is true too. If, like Melissa says, if a child tests for lead in their blood and it comes up positive for a certain percentage, I think it's the Department of Public Health that can do a lead inspection of the home. But if you want a concrete answer, we'll look that up and send that to you.
Well, thank you, presenters, Carrie, Jolene, and Melissa. What great information you have shared with everybody today. Just as a reminder, please fill out the evaluation form that will pop up at the end of the webinar. And if you're looking for continuing education credits, you're required to fill out the form and make sure that you have put your number and your name in the chat box to get credit. And then finally, I just want to say thank you to the sponsors of the webinar series again. They're on your screen right now. Again, the webinar will be sent out and posted on the Ohio Healthy Homes Network. Thank you for participating and learning more about medical legal partnerships today. Thank you to the presenters and to Ohio for organizing everything. I hope you have a great rest of your day. Thank you.
Thank you.
Thank you. Bye-bye.